Thank you. So my name is Matt. I'm a graduate student at Arizona State University, and I've been working with Timmy Ebby for the past year at the Space Governance Lab that we are officially launching tomorrow, which is really exciting. But we're here to talk about more of this contest. So a little bit of history about me. Space actually isn't my background. My background is actually as a molecular biologist. For 3 years, I studied vaccine production for HIV and HPV. And leaving that space, I decided to dive headfirst into policy because I felt like that's where I had real impact to be made. And that's where I joined as a graduate student at the School for the Future of Innovation and Society. And that's where I eventually bumped into Timmy as well. Timmy, do you want to introduce yourself before I keep going on about the contest?
Perfect, thank you. Hi everyone, my name is Dr. Timmy Abiyagana-Bajansi. I'm an assistant professor at the School for the Future of Innovation and Society and courtesy professor at the Arizona State University Law School. So in way of a little bit of a brief introduction, in 2018, in partnership with the Secure World Foundation and co-hosted by the Center for Innovation, Development and Society at the School for the Future of Innovation and Society, we sought to bring together USAID, NASA, and some other partners in Africa to explore a really important question. So if space is really supposed to be explored and utilized for the benefit of and interest of all, how does it benefit a specific user group? For instance, we focus on African women farmers. And we really put a challenge to NASA and all these actors and said, okay, tell us how exactly does the African, the African woman farmer benefit from space? And you can imagine it was a challenge. But we discovered, there are all these technological solutions and all these problems with them actually being able to translate to the local level. And so we saw that, this idea of technological futures and accessibility is not there for everyone. And this is the background of the impetus behind what led to the work that we started doing in Africa. So Matt is my able project manager, and I'll let you go ahead, Matt.
Yeah, so I am going to keep this a little brief because we are running close to time, but Space Governance Innovation Contest came out from this idea of expertise that we have at SFIS. Within space policy world, there is a lot of smart people working in it, but the breadth of experience that comes from it can be a little difficult to work with. And so we thought to ourselves, well, we have these great big gaps in international space policy that we need to fix. Where can we look to fix it, and how can we really increase the amount of solutions that we're getting to it? And so we had this idea that we'd launch this Space Governance Innovation Contest inspired by a similar project, the Stockholm Treaty Lab, who try to do something similar with climate change and climate policy. And we thought to ourselves, well, let's make this contest open. Let's open it up to young Africans and African students, and let's see what their ideas are. And to add some rigor to it and to make it more robust and to see what they can really achieve, let's do 3 major things. Let's engage with them. And by engage, we don't mean just kind of emailing them. We mean really engaging with them, really throwing our weight behind them to make sure they succeed. Let's support them in any way that we can. So as they were in this contest, we tried to make as much resources as we could available to them. The resources we had available at ASU were certainly available to them as well. Just anything we could do to make sure their submissions and anything that they would want to work on, need help with, they could have access to it. And they then ran with it and they took off. And what you're about to hear today are from the 6 teams that were selected from the 8 who submitted. They came from 5 different countries in Africa, being Nigeria, Ethiopia, Libya, being a few of them. And what we're going to start off with today is from those 6 teams, their names are Team Luminous Elite, Team Perseus, Team Alpha, Team Gravity, Team International, and Team Thinkers as Doers. Each team is going to have 8 minutes to present their ideas. Judges are going to have 2 to 5 minutes to ask questions. And we will be going on until we hit a keynote at the end where judges will be discussing during as well. I know I kind of wrapped in a lot of logistics with also what the contest is about. I might have missed something or I talked too quickly. Timmy, I don't know if you wanted me to cover anything that I might have missed.
Nope, we're good.
Right, perfect. So if, without further ado, Team Luminous Elite, are you on the line? Can you hear us? There you guys are.
Hello, good day.
Yeah, so I'm gonna go ahead and keep time. You guys have 8 minutes to present your idea, and then you're gonna receive feedback for the judges. So whenever you're good to go ahead.
Okay, I can start now. Good day. I am Fawaz Aaron, and with me today is Shalom Ashibade, both representing Team Luminous. And the space policy gap which we have identified has to do with space debris and the lack of a framework in the space law regime to provide for space debris. Basically, Basically, due to the lack of a framework to provide for space debris, it is impossible to take care of this problem. And with our presentation, we seek to provide solutions, to provide solutions. Firstly, our model instrument was Shalom, please go. Shalom will be continuing now.
Okay, thank you. So I'm Ajibade Shalom, and the policy gaps we identified regarding the treatment of the issue of space debris are in threefold. First is definition, second is state responsibility, and lastly is inadequacy of mitigation alone. On the first issue, the most basic of all space laws are the US space treaties, and none of them mentioned space debris at all. Of course, it's not surprising at the time they were made, it couldn't have been so envisioned that such may happen. But the problem is an issue not recognized, institutionally recognized by the basic laws. How do we hope to solve it? To recognize that there have been soft laws regarding some of these issues. The COPOS and the IADC have provided definitions of space debris, and we propose that this should be incorporated into a hard law instrument, preferably a protocol to the Outer Space Treaty, a protocol that will be specifically based on space law remediation and mitigation. And next is the issue of state responsibility. The question of state responsibility is, do states really have the obligation not to place debris in space? And would they be liable when they do so? This question played out where China, as well as India, performed anti-satellite weapon tests. And all the international community had to do was just social program. No one felt the obligation to take this on them in a legal means. And this is because there is no means of impinging obligation on them. The closest of this is contained in Article 8 of the Outer Space Treaty, which seeks to prevent states from harmful contamination of the outer space. But the problem with this provision is that it is rhetorically couched in that it does not provide for any means of enforcement. It does not give a clear notion of what harmful contamination means. And the next issue is the inadequacy of mitigation regime. We recognize that there are mitigation regimes, guidelines, all soft law as well, which are best practices among space agencies. But the issue is that aside the fact that these mitigation regimes are losing touch with the reality of space launches, especially in considering the case of constellations, we also recognize that even if we stop to launch, the amount of space debris will always increase, considering the chain reaction caused by the Kessler Syndrome, which is if we don't even launch, we'll still have more of this debris. So we need a removal regime. And this brings me to the solutions we prefer for all of this. Concerning state responsibility, we are faced with some painful and not painful, but realities of international law and international relations, which is, it is based on consent. And consent will only come where these frameworks are satisfactory to state. And for us to create a binding instrument, we don't have that time for now, but we have an alternative to all of this, which is having to view space not as something far, but as a human environment. That way, international environmental principles can be applicable to space and can also be used to assign responsibilities to states. In that regard, environmental principles like environmental impact analysis, precautionary principle, and polluters pay can be used to tie states down to some responsibility in making the space, outer space, sustainable. And We also prefer an improvement on the fault-based approach contained in the Liability Convention of 1972. The fault-based approach was not defined. What amounts to fault was not defined. So in our modern instrument, we also prefer the introduction of a sort of an agency which will be majorly controlled internationally from the UN, which would, in line with, in conjunction with Scopus, give guidelines, strict guidelines on space traffic management. So that will determine fault of states, where states neglect to follow any of these traffic management regimes provided by this agency, then it will amount to fault under the liability regime. And of course, we'll now move on to the inadequacy of the mitigation regime. Like I mentioned earlier, mitigation is not enough, and we need a removal regime. We also have issues with removal regime as well, issues like funding and alternative use. But as regards funding, like I mentioned earlier, environmental principles can help. Environmental principles like polluters pay are very essential in that every space mission has the capability of creating debris. Therefore, if each space mission is built on this account, we could create a financial base which could be used to fund our removal regime. And the issue of alternative use as well. Alternative use is one concern that states have had regarding this, and this can be solved by proper supervision by the agency that we seek to introduce. And that rounds up our presentation on the policy gaps and the solution we prefer for these policy gaps. And thank you. I remain Adibade Shalom, and this is Arun Fawaz, and we are Team Luminous. Thank you. Thank you.
Thank you very much. Just before we open up to a few questions, if I see that there are people in the attendees that should be participants, so please write your name in the Q&A so that you can be added to the participants list. Thank you. Okay, please, 5 minutes open for questions.
Well, I could begin with one question. Thank you, Group Luminous Elite, for your presentation, very interesting presentation. The question that I have is in regards to your suggestion of using some of the ideas of international environmental law. So I was wondering if you could tell us a little bit more about what you see as the gaps that international environmental law would fill that are not currently filled by, say, the Liability Convention or the Outer Space Treaty. Oh, and by the way, I'm sorry, I'm Chris Borgen from St. John's University Law School. Thank you.
Thank you. So the policy gap that we recognize that international environmental law could tackle is the idea of state responsibility. The Outer Space Treaty was not really had on the harmful termination, the term harmful contamination of outer space, which has led to situations where states have deliberately contributed to the amount of debris and have not been held responsible for such. But with environmental principles like polluters pay, with environmental impact analysis, especially considering the nature of constellation launches, this could help fill the gap of state responsibilities in that regard. Thank you. Do you have, thank you. Thanks for the question.
Any other question?
If there's no other folks willing to go forward, I think I can start with some comments and hopefully phrase it into the form of a question. So good morning, everyone. My name is Chris Johnson. I'm the Space Law Advisor at the Secure World Foundation. I also teach space law at Georgetown. I was very interested in this idea about a protocol to the Outer Space Treaty that would do a number of things, that maybe a definition of space debris or greater clarity on what we mean. The the certainty that international environmental law applies to outer space, the idea that we need some type to have some type of removal regime or space traffic management regime. But I think that, you know, when we look at space activities, it's basically every single launch to outer space for the past 50, 60 years creates debris. It's essentially impossible to get to space without creating some debris or, you know, totally eliminating the risk of space debris. So that's part of doing business in space activities. I think that it impacts how we do these things and how we develop this protocol or your solution. The other thing is that, you know, space is a different domain in terms of orbital dynamics, celestial mechanics, you know, approaching an object, removing debris, and also proving where that object comes from is different from other domains and domains on the ground. So, you know, while we can transpose some of these rules from terrestrial law to the space domain, I'd like to hear a little bit about, you know, how you intend to solve or address these issues, that space is a different domain. And if we're going to do a protocol to the Outer Space Treaty, some elements from international environmental law can be transposed, but we're going to have to adapt them. I wonder if you have any responses to that. Thank you.
So, okay, thank you. Yeah, like you said, there's little possibility that a launch will not create any debris. And like what we propose is that we need a removal regime. And in fact, the fact that launches are that way provides a bit of solution for us regarding funding. If we apply the environmental principle of polluters pay, that is, every launch we have to pay, because every launch can not prevent themselves from creating debris. That will solve the problem of funding of the removal regime. And of course, these environmental principles, we have to be adapted to space situations and technological needs of the space as well. And of course, the engineers and would help with that.
I would also like to add that we recognize that it is impossible to totally eliminate the emergence of space debris. However, we have to take conscious efforts to reduce it as much as we can. That's all. Thank you for the question.
Yeah. Then,
thank you.
So to add something little, then something from environmental law which could be also helpful is the target approach. We should see the issue of space debris as a large problem is one of our issues, but having targeted responses, our mitigation regime, we should say, although each launch must create a debris, but this should be the limit of this debris. Like every launch should try to limit their debris creation to these numbers, to that number. And our removal regime, although we should start with these types of objects and this number of them per year, dedicating an amount of years to consistent removal of space debris. Thank you.
Thank you. Matt, I believe that we're out of time, so what's the next team?
So next team we have Group Perseus is going to be presenting for 8 minutes. So if I see correctly.
Yes, I see Group Perseus. Go ahead.
Good afternoon, everybody.
Good afternoon.
Can you hear me?
Yes.
All right, I'll proceed now. So good morning, everybody. My name is Victor Adewumi, and I'm from King Precious, and it's a pleasure to be here. So our presentation today is in 2 parts. I'll be taking the first part of our presentation for 4 minutes, while my teammate Mosumola will handle the rest of the presentation also for 4 minutes. All right, to provide some background, just a few days ago, SpaceX, a company founded by Elon Musk in 2002, made history as the first private company to send astronauts to the International Space Station aboard the spacecraft Dragon 2. Similarly, Blue Origin, another spacefaring company founded by Jeff Bezos, has also unveiled its vision for space and the plan for a moon lander proposed for year 2004. So putting all of this in perspective, the participation of non-state actors in space activities can no longer be marginalized, thus bringing to fore the inherent policy gaps in non-state actor participation. It is against this backdrop that Tim Perseus proposes a model instrument, the convention regulating the activities of non-state actors in outer space. All right, moving forward, the first policy gap that we have addressed in our model instrument is the ownership of resources obtained from outer space by non-state actors, considering the principle of non-appropriation existing under the current regime of space law. To start with, Article 3 of our model convention provides on the free use and exploration of outer space by non-state actors, providing specifically for the mining of outer space resources by these non-state actors through the issuance of mining licenses to such non-state actors. We agree with Alexandra Venue in his article, The Rights of Private Actors in Outer Space, when he proposed that the United Nations Committee on the Peaceful Use of Outer Space, COPOS, to be a competent authority for issuing and revoking licenses. We also propose that the conditions for the issuance of these licenses or permits for space operations would be subject to international obligations and commitments. While we understand that this article might be the most contentious of all the articles contained in our instrument, bringing to fore particularly the principle of non-appropriation, we submit that the license to mine does not confer ownership of any portion of outer space, including the moon or other celestial bodies, on non-state actors. On the contrary, the non-state actors will only have ownership of mining proceeds derived from the mining activities, which is what is technically termed as profit apparent rate. This principle only confers proprietary interest in what is taken off the land and not the land itself, thus neutralizing the fear of outer space being monopolized or appropriated by non-state actors. We can also draw inspiration from the United Nations Convention on the Law of the Seas, the UN clause. While Article 137, paragraph 1 of the UNCLOS recognizes the IC as the common heritage of mankind, which cannot be subject to appropriation, paragraph 2 of this same article also goes ahead to provide that minerals recovered from the area, that is the ICs, can be alienated subject to regulations and procedures of the International Sea Committee, which is the creation of the UN clause. We submit that this same principle should be extended to current space law regime, where there will be a committee, where the COPOS, that is the Committee on the Peaceful Use of Outer Space, will be empowered to issue licenses for the activities of non-state actors in outer space. The next policy gap that our model instrument addresses is the sharing of space benefits with the view of protecting the rights of Africa and other developing countries. We understand that the commercialization of outer space resources is a looming reality, considering the realities of the time. With the mining of resources from outer space, a market for the trading of these resources is bound to emerge. So we propose that in the face of whatever market realities that will emerge, the needs of Africa as a continent, and those of other developing countries, that is the third world countries, should be put into consideration. The sharing formula should be put in place, of course, to protect the interests of countries that are not yet developed enough to become spacefaring in their national policies. And we again allude to the provisions of the United Nations Committee on the Law of the Seas, particularly at Article 140, specifically paragraph 2, which provides for the equitable sharing of benefits derived from the ICs through any appropriate mechanism on a non-discriminatory basis. So in conclusion, we submit that the principle and the immutable principle the cardinal immutable principle of international space law contained in Article 1 of the Outer Space Treaty remains the same, that the use of outer space shall be in the interest and for the benefit of all of mankind. We submit that our model instrument does not in any way contravene the existing principles of space law regime. I will hand over to my teammates now, Musun, to continue with the rest of our presentation. Thank you very much, everybody.
Thank you very much, Victor. My name is Musmola Adefarti, and I'll be addressing our remaining innovations. So one of the innovations we proposed in this convention is the principle of shared liability. That is the fact that liability for damage done to outer space, personnel, or even the Earth should be borne by states as well as non-state actors. So under the current space law regime, the Liability Convention, to be precise, states alone bear liability, whether absolute or fault-based, for their actions as well as that of their nationals. But with the increasing participation of private corporations in outer space exploration, we believe that it becomes very paramount that some level of liability for wrongful acts in outer space is borne by these entities. And at the end of the day, we believe that an imposition of shared liability would be a corollary for an increased responsibility in non-state actors carrying out their activities in outer space. And also in our model convention, we proposed a dispute resolution mechanism. And the dispute resolution mechanism we proposed is MEDAB, which is an hybrid of mediation and arbitration. And I think we must point out the fact that MEDAB is not a new concept. It has been successfully used for the resolution of commercial disputes in countries like Hong Kong, Canada, China, to mention but a few. So essentially, parties to a dispute would submit a dispute first for mediation. When mediation fails, they would then submit their dispute to an arbitral tribunal. And we believe that the laws governing the arbitration should be the Permanent Court of Arbitration optional rules for arbitration of disputes relating to outer space. While we must point out the fact that MEDAB, like every other form of dispute resolution, has its own shortcomings, we have the opinion that its benefit definitely outweighs the cost. We believe that MEDAB remains a faster, a more cost-effective, and a private forum for the peaceful resolution of disputes. And finally, ladies and gentlemen, one thing we are seeking to do through our model convention is providing certainty. The current space law regime has not provided that. And as much as possible, investors want certainty. They want to know if they would get return on their investment. And we believe that this convention provides certainty and clears doubt in the mind of prospective investors as to ownership of resources, sharing of space benefits, as well as a formidable dispute resolution mechanism. It has been said that the space economy is projected to hit $1 trillion mark in the coming decades. And the way to stimulate major involvement of non-state actors would be to provide assurance around fundamental principles delineated in the Outer Space Treaty. We believe that this convention can do that, and this convention should be adopted. Thank you.
Perfect. Questions? Pam, you're on mute.
2 minutes.
Sorry, yes. Musmola, I was actually quite interested by your bringing in MEDARB as a possible way to sort of resolve disputes. So my question, I think, is, in the current context of the space treaty as we have it, what little there is of it, you have principles that say something about the states retaining jurisdiction, control, and ownership, and whether it's even responsibility for objects that are launched into outer space. Considering that, Group Perseus, you've focused on non-state actors. Say a non-state actor launches something out in space, right? Now, you've mentioned arbitration. Who would you say would be the right party there? Which party would have the standing to actually take on this? I mean, where would you go to attribute responsibility in this context?
Thank you very much. We understand the fact that states, of course, retain jurisdiction as to launching of space objects, but we also realize the fact that there are certain instances where there could be disputes which might not necessarily be as to launching of space, or as to launching of spacecraft. There could be other commercial related disputes, for instance, contractual based disputes. And we believe that arbitration or MEDAB will be a formidable means to resolve the dispute. For instance, we foresee a likelihood of, say, a dispute between two non-state actors, for instance, two non-state actors. So maybe a contractual dispute in that sense. So in a situation like that, MedAb would be the perfect dispute resolution mechanism for peacefully resolving the disputes.
Okay, we're gonna have to move on to the next one. Ooh.
Thank you, Tim Persis. Okay, who's next?
Team Alpha.
Team Alpha.
Hello, I'm just sharing my screen with you all. Are we free to use presentations today?
Do you need to use slides? Can you do it without
Yes.
slides?
I could do it without, it's still fine.
Go ahead, do it without the slides.
Okay, no problem. So my name is Ravimbo Samanga. I'm representing Team Alpha today, and my team participants are Ms. Feben Marcos Sunde from Ethiopia, as well as Ms. Marian Wamere Muriuki from Kenya. We selected the policy gaps on scale-up of megasatellite constellations, and we found these gaps particularly pertinent in the African context, firstly because that scale-up of megasatellite constellations present the most immediate and practical development in outer space at the moment. Secondly, we believe that Africa's burgeoning satellite and launch manufacturing industry requires bolstering through policy. And thirdly, satellite technology and Earth observation data provides tangible, sustainable development solutions to Africa's challenges. And it was very essential for us to take note that the megasatellite constellations operate within a very tenuous orbital zone known as the lower Earth orbit. So to that extent, we decided to name our model instrument the Convention on the Peaceful Uses of the Lower Earth Orbital Resource. And just a few characteristics of the low Earth orbital resource which have informed some of our provisions in the model instrument. Firstly, it is a high resolution and signal strength zone, making it a very valuable orbital zone. And secondly, it has a small coverage area over the Earth's surface, which also translates to a limited coverage window for any specific geographic region. So it is quite limited and scarce in that regard. But nevertheless, it has tangible benefits for Earth observation, surveillance, reconnaissance, weather collection, manned spaceflight, communications, and most importantly for Africa and the fourth industrial revolution, high-speed internet broadband. So to this end, we found that this would be a very important area to regulate, and we had 4 specific thematic areas that we looked at in our model instrument, and these were mainly access, coordination, debris mitigation, and liability. So I will deal quickly with each one in turn and discuss our respective innovations in that regard. So with regard to access, we're speaking here, referring to spectrum access, and we uncovered that there was an urgent need to avoid spectrum warehousing through establishing a new spectrum management model, which would necessitate that states create or establish national demand mapping and forecasting in order to equitably distribute spectrum allocation, and that for this new technologies could be proposed, such as artificial intelligence algorithms for allocating spectrum, and even blockchain sort of technology for peer-to-peer lending of unused frequencies or frequencies that are not being used efficiently. Moving on to coordination, as a space lawyer, we're very fortunate to not have had a lot of collisions in outer space, but we do have an example that we can extrapolate from, which was the Iridium and Cosmos collision. And from here, we noted that there is an urgent need to coordinate these multiple satellite systems, and an urgent need for a space safety coordination system, which would require active participation by all nations. And to that, our model instrument mandates the establishment of a National Joint Space Operations Center. We sort of gleaned this idea from the National Joint Space Operations Center that's envisioned by the Space Force in the United States. And the whole premise is that it acts as a tracking system for public and private space systems. We do also understand that ESA has recently established a consortium for tracking, and we do not want we do not propose a separate system to that, but rather that this would work complementary to that pre-existing establishment. How that will work is in the vision of a shared or joint African space agency. Each country can submit their tracking data to AfriSpace, which is the African Space Agency, who will then act as the continental representative to the worldwide tracking consortium. Moving along, we also have the issue of space debris mitigation, concerning how we can curtail the generation of new and potentially harmful space debris in the near term and limiting generation in the long term. This would require active collision avoidance maneuvers, as well as mandatory satellite deorbit, which according to the current standards is 25 years, but owing to how particularly tenuous the lower Earth orbit is, this would possibly be reduced to 10 or even 5 years in order to maintain sustainability there too, and also active debris removal. And active debris removal in this case constitutes many different methods such as expanding foam, rocket propulsion on satellites, or even the concept of salvage, which is gleaned from international law, whereby any state with the capabilities to do so can actively use technologies that will effectively clean up space. And they can receive compensation for doing so. We also had a few provisions on liability and dispute resolution. Of course, gleaning from the 3 thematic areas already discussed, you can get a sense of what would constitute liability in this regard. First of all, physical harm or radio interference would constitute possible grounds for liability, as well as the failure to advise on conjunction or possible conjunction of satellites if we're speaking on matters of coordination. Also, a failure to implement adequate debris mitigation practices. And I think it's important here to mention that in this case, that the principle of erga omnes can actually find application, whereby a state who's not actually directly implicated or injured by space debris, or potentially could be injured by space debris, does not have has the ability or the opportunity to institute a claim against another party for their space debris. So in this case, they would be acting in the interest of all mankind in instituting such a claim against the offending party. Because as we all know, space debris, even though if it is far removed from the instituting party, can trigger what's known as the Kessler Syndrome, whereby space debris begins to collide with one another and cause a chain effect, which could eventually damage the whole entire space satellite ecosystem. And this scope of liability obviously also extends to private actors, and we also propose a tiered system for resolving of disputes, owing to the fact that states still have to accept responsibility in terms of the International Court of Justice. All state-to-state conflicts will still have to submit themselves to the ICJ, and all non-state to non-state disputes will submit themselves voluntarily to some form of alternative dispute resolution, and the same would go if it is a non-state versus a state actor. And then how we finance this model, one of our innovations was that we set up a continental or sub-regional stock exchange. And we chose this model because a stock exchange is the basic indicator of stability and prosperity of a country. It has tangible benefits such as governance structures, access to capital, and also high investor interest, especially in space, owing to the fact that satellite systems will have far-reaching implications for the 4th industrial revolution, cryptocurrencies, blockchain, cloud computing, and all that. There will be sufficient investor interest to pool enough funds to fund space initiatives on the continent. And we can use a model similar to the S&P 500 model, which will list sort of the top 500 space companies in Africa for crowdfunding. This also gives the public an opportunity to contribute to outer space affairs as well, and feel as essentially they have a stake in what's happening in outer space. And finally, to coordinate all of this, we need a regulatory authority. And in our model instrument, we propose that the United Nations Office for Outer Space Affairs best fits this role. We believe that having a regulatory authority is vital towards a space economy. And we have selected UNOSA, mostly because they are already the drivers of responsible innovation. They are presently engaged with multiple stakeholders, and they also have a variety of legal, scientific and technical facilitating high-level technical subcommittees that facilitate high-level discussions on space innovation, which is really the kinds of forums that we need to stay abreast of legal developments in outer space. And members can sort of submit to UNOSA through voluntary cash contribution, sort of the same model as the WHO, in order to support the work of UNOSA in developing space capacity in Africa. So our final policy recommendations to make this model feasible and practicable involve the standardization of definitions, the declaration of LEO as a limited natural resource, the elevation of the IADC guidelines to binding standards, and of course, capacity building in Africa. And the international law principles that have sort of informed these provisions include freedom of access and equitable use, which of course involves the predetermined frequency allocation, as well as freedom from harmful interference, which is expressed in the space safety coordination. Furthermore, the precautionary principle or the concept of salvage or the concept of ergo omnes finds expression in requirements for active debris removal.
Team Alpha,
I
have to get you to round up.
Okay, no problem. And of course, we make mention to international principles of responsibilities of states and international cooperation and sustainability. Apart from that, we also do make specific reference to certain definitional elements, especially space debris and what constitutes space debris, as well as making definitions on satellite, the lower Earth orbit, space, satellite mega constellations, investment, and what constitutes a space economy, which are all lacking in the current regulatory frameworks. And with that, I will humbly take my leave.
Thank you so much, and well done for being able to, work on cue. Any questions? Yes, the Christopher Borgen.
Yes, I have one question about active debris removal. So Article 8 of the Outer Space Treaty says that a state of registry shall retain jurisdiction and control over its space objects. If in having active debris removal, do you view that if there are third parties that are removing that debris, that they would have to get permission of the state of registry? Or do you view that they would be able to remove that debris without the permission of the state of registry?
Thank you very much for the question. I do not think that they would have to get permission in order to remove the debris. I think that in the principle or in accordance with the principle of ergo omnes, the state acting according to salvage or acting on the basis of salvage would have basically the interest of all mankind at heart in taking appropriation over that space debris. And I think that we need to make a distinction between space debris and space object. And I don't think that space debris would fall as an object under the jurisdiction of a state, but rather becomes a free-falling object in outer space that has capacity to unduly harm other state parties, and that becomes an international concern or international interest in which another state party must then act responsibly in order to mitigate. I hope that answers your question.
Chris Johnson, briefly.
All right, first off, there's a wealth of ideas in your presentation. Please write them up into a publication afterwards. Whether you win or lose, please write up all of these ideas. 2 questions. It seems as though you are creating salvage rights. Please confirm that. And then are you also proposing to alter the liability rules, the pre-existing space law liability rules? It seemed as though you were.
So yes, indeed, we are creating salvage rights. A state that does engage in any act of salvage is entitled to some form of compensation for using their technology in doing so. And in terms of the dispute resolution system, what we actually tried to do was to act in accordance with existing principles of international law and existing supranational legal frameworks, which is why we sort of submitted that states would remain under the supranational legal framework of the International Court of Justice, which is sort of what stands already for international law disputes, and that private companies would, as in any commercial arbitration dispute, would have the option to alternative dispute resolution.
Thank you very much. Excellent job. Next team, Matt.
We're at Group Gravity.
Gravity, go ahead.
Good day, everyone. I'm Akinpelu Akelua, the representative of Team Gravity, and I'll be presenting with my colleague, Zara Okadigo. Without further ado, I'll go into our presentation by policy gaps that were identified in the Outer Space Treaty. Firstly, we were able to classify them into two broad groups, the habitat issues and the orbital and suborbital issues. I'll start by discussing the point of the non-appropriation of outer space between the moon and other celestial bodies, which is provided for under the outer space treaties. We extended the coverage of this to include that whether state parties, whether states, natural or juridical persons, they cannot exercise any rights or any claim of sovereignty to the space or its resources. We also included that scientific research conducted in outer space between the moon and other celestial bodies shall not form the basis of any legal claim to any of the resources located in the outer space. Also, still on the scientific research, we included a clause for the promotion of international cooperation in such scientific research between state parties, whether within state parties, and also between international organizations, and also the private sector, in view of their major role they are beginning to play in the space sector. In also ensuring development and cooperation in scientific research, we made a way for less developing countries and less technologically advanced countries for them to create programs for them, in order to enhance their research capabilities and also train their staff so they can be moved along with the trends in space. We also provided for the establishment of a body, that is the International Outer Space with the Moon and other celestial bodies, that will organize and control the activities of the spacefaring countries, in respect of the resources. Also, a commission under that, which will include both the members of the international organization, the members of the corporation or private entity which is exploring space, and also a third-party organization who also has interest there in conducting scientific research or inspection or supervision of the activities in outer space. We decided not to limit it to just members of the international organization and the international organization and the private entity actually exploring the resources, in order to promote various views and for them to serve as a watchdog to the activities in outer space. Lastly, we provided for a civil spaceflight organization, which will be a form of subsidiary to the current International Civil Aviation Authority, in view of the prominent role of space tourism now and private activities now in space now, for them to be responsible for the licensing of such activities and to ensure the spaceworthiness of such vehicle to perform similar functions as the International Civil Aviation Organization. I will now hand over to my colleague Zara to continue with the presentation.
Good morning, I am Zara Kadibo from Sim Gravity. So the second umbrella for our issues was the orbital and suborbital issues. And under that, I'll be talking about the weaponization and the militarization of the outer space. So it's an accepted notion that the Outer Space Treaty, having no ownership, is meant to be a peaceful province and for peaceful purposes. So to caution this, Article 4 of the Outer Space Treaty prohibits the carrying to outer space nuclear weapons and weapons of mass destruction. However, we saw this provision to be somewhat backdated as it is not in tune with recent developments. So according to our model instruments, we widened these provisions and not only prohibited weapons of mass destructions, but also prohibited nuclear weapons and weapons of anti-satellite weapons and other conventional weapons in general. We also saw that the militarization of outer space is somewhat under the cushion of the weaponization of outer space. It then poses a question, is the military use of outer space a peaceful use of outer space? And simple answer, no. The space is no longer a peaceful domain, as any fight on Earth could easily snowball into this space. So there are laws governing armed conflicts, but while being prepared, they do not factor wars that will occur in the space environment. Therefore, the principle that will govern laws of wars cannot be applied directly to the space environment. To that extent, we prefer that there is a need to develop a policy framework that would objectively articulate and also clarify the existing international law that are applicable to militaries of outer space, and which will also factor. So when we propose that some documents put in place for military weapons have simply not been effective, documents like the Harvard Manual and sorts thereof are simply not effective. So we say that there is a need to have a serious meeting that will require negotiation by each spacefaring state, talking about the actual laws that should guide the military use of the outer space. So the second thing we spoke about, we addressed, if you're following, please, was the space tourism. So Article 5 of the Outer Space provides that astronauts and envoys of mankind in the outer space shall be rendered to them all possible assistance in the event of accidents and all sorts. However, we saw this provision to also be kind of limiting, because considering the supposed privatization of outer space with the SpaceX and all sorts, we preferred in our model instruments that it should not only protect astronauts as envoys of mankind, but also cover space tourists and space travelers and every other private company that goes to space. So we saw that this article should also cover them. If I still have time, I want to talk a little bit about power asymmetry, because we also thought in our model instrument that in order to avoid the repeat of the Rome Statute experience, and since African leaders in spacefaring are not sufficiently positioned to compete, and the need to harness space environments for civilian businesses and military purposes will be key in establishing a nation's military might and influence. So also business opportunities and capacities in the 21st century and beyond. Consequently, developing margin representations on the commissions and committees is very key. So the authorities body headquarters should be located in one of the fairly developing spacefaring nations like South Africa or something, so places where there is no bias and it's simply headed by a developing country. Conclusively, and because of time, we just think that the Outer Space Treaty is more or less sacrosanct, and our model intends to collate the new thoughts into a set of norms or principles or guidelines which member states can accede to, especially in the wake of private corporations and in the space of the launch of SpaceX. So our model instrument simply focuses on the benefits of states, corporations, and developing nations and preserve their interests without compromising the peaceful uses. And we think that it is not so far.
Thank you, Zara. Does anyone have any questions for Team Gravity? Yes, George, you're muted.
On your talk on the militarization of space, do you make a distinction between military use and police action, or do you think there should be such a distinction between those two with respect to a state?
You said difference between militarization and police action.
Yes.
There isn't necessarily a difference, because unless we can particularly point out what exactly a peaceful use of outer space would be and peaceful interaction of outer space would be, every other thing that involves the taking of traditional weapons or traditional weapons to the outer space is simply not peaceful use of outer space and will go under the militarization of outer space. And if we eventually allow for that, it's more or less, throws away the purpose of the Outer Space Treaty itself, which is meant for a peaceful province and something sort.
Thank you. One more question? Great. Matt, how are we doing for time? Are we good?
We're doing great.
Okay.
We're actually a little bit ahead now, but if you want to move on to the next group, our next group is Team International.
Team International, you're up.
Good morning.
Good morning.
Good morning. I'm Paul Sule, representing Team International. Also with me is Yetunde Biodun, who obviously said he had technical network issues. He will join as I give him some part to take. The theme of our argumentation essay is unmasking international space law and policy for the benefit of mankind. And gaps we have identified is in the management of space resources for the benefit of mankind. Now, how do you manage space resources in a manner that benefits mankind? We said the law, when it was made at the time that the space treaty, that is, the extant treaties were made, the focus was on state parties who were parties to the conventions that were agreed, even though some of them were not overwhelmingly supported by the state parties. Now, the reality of today is that we have more space, private space entities conducting their activities in the space environment than we have the governmental state agencies. Even the governmental agencies are cutting up their budget in order to hire the services of these private space enterprises. And our gaps is to manage these resources by setting up an authority akin to that in the International Seabed Authority under UNCLOS to manage these resources and ensure the enforcement of debris mitigation guidelines issued by the Committee on Peaceful Use of the Outer Space, and also set up a dispute settlement mechanism that will work more efficiently for all the stakeholders. We have identified the stakeholders to include sovereign states, international, specialized international organizations, international corporations, and even national corporations, as well as regional blocs like the European Union and the Africa Space Agency. So these emerging stakeholders were not factored into the issues that were dealt with at the time of coming out with this law. Now, how do we incorporate them? How do we give them the opportunity to play active role in the development of the emerging space-oriented economy is our focus. Now, in doing that, we said, since there are so many concerns ranging from scholarly critics and economical dimension, political dimension, sociological dimension, as well as even cultural dimension, are calling for the regimes of this law in order to accommodate those interests. Then we said a law that will work perfectly must first prescribe actions or inaction in that environment, as well as put resources in place, organize resources for tackling issues that may arise as we go forward. Now we said our model instrument has provided for a system of contribution of a percentage of the proceeds that an actor, whether state or even a private entity, made in the outer space, using the outer space resources for scientific or economic gains. He must give a certain percentage to this authority in order to manage in trying to enforce, or sorry, in trying to ensure that the mitigation guidelines are taken, as well as the interests of entire mankind are also taken into consideration. And this system, we also agree with the system of a sharing of liability done on the basis of the Convention for Registration of Objects. Now, since those objects are registered before they are launched into the space, we know those who own them. And since we know their lifespan, we know that they are not longer in use. So we can take from there and ascertain the number of contribution to the debris that is in the outer space and allocate some kind of financial contribution on these actors in order to help the regime that we propose to clean up the space and mitigate it so that other users can have access to the space environment. And space economy, we say today it is almost 400 billion United States dollars. And like Morgan Stanley said, it is going to be over 1 trillion US dollar by 2040. So that mostly the participants now are private actors like Blue Origin, Virgin Galactic, Aerospace, SpaceX, Blue Aerospace, Axiom Space. These two, the Blue Aerospace and Axiom Space, are planning to replace the International Space Station by a commercial and a expandable version of the model, which people believe that it will be more efficient or more effective than even the International Space Station that we have currently in the low Earth orbit. Then we talked about mitigation of state debris. This state debris mitigation, we adopted the guideline issued by the Committee on Peaceful Use of the Outer Space, subject to periodic review by the International Space Economic Council, which we propose to be established in our model instrument in Article 12 to be precise. And we believe that this will accord the opportunity for those, like I mentioned earlier, those who were not hitherto active players in the management or taking policies in this environment to have the opportunity of contributing towards the development of the economy. And also the need, we also consider the need of having a system of dispute settlement. This is because since the space race, we have similar to having, conflict between states when there was when an object, a radioactive debris, was deorbited and fell, belonging to USSR, the Soviet Union, fell in the Canadian territory in 1978. What they used to resolve that, Canadian actually made a complaint through the Liability Convention, but it was resolved through diplomatic means, exchange of letters, diplomatic letters between the parties. Then we say, since that is the case, we advocate for an amicable or peaceful resolution of conflict initiated by the parties themselves, just like the diplomatic letter used in the case of the Canadian case and the Soviet Union. And also we say, since the organization is on mutual respect and voluntary participation, a peaceful resolution of conflict will be most effective, most especially if it is scalable to accommodate future occurrences which are not contemplated or not present at the time they were written. And also we say any innovation must be responsible in managing these resources. How can we make it responsible? Those who initiate it, those who are to do it must be involved in a system that accommodates them as moral and responsible agents, so that they will have knowledge of their consequence, the likelihood of their consequence, or even inaction in the spatial environment. And we concluded our argumentation by saying the model instrument we found will be useful in that it is in line with the existing or the extant laws of international law. The regime for liability convention is also incorporated into our model instrument. We retain that the states shall be liable for, internationally liable for the actions of their governmental agencies as the non-governmental agencies, but it shall provide a law, an insurance law, that will make the state recoup this liability must have incurred on behalf of a private entity internally. And also the system, the council we proposed, we said it will have representative from all states and also representative from the United Nations Committee on Peaceful Use of the Outer Space. Now, these representatives of state will elect a chairman of this authority, who shall function for a period of 3 years. And the main function, as we enumerated in Article 13 of our model instrument, is to regulate the product emanating from scientific, economic, or commercial use of space resources. The council shall also set guidelines and standards of licensing private operator by state parties, including procedure for environmental impact assessment. Ensure compliance with that.
Can you conclude? Can you conclude?
Hello?
Can you conclude, please?
Okay. We have also said the area of investment in this can be through monetary or non-monetary. Monetary investment can be research and development, building of space infrastructure, and also manufacturing of satellite accessories, propulsion or transportation services, delivery of payload, humanitarian. Non-monetary can be educational training, technical support, or even a partnership or a contract where a state entity can provide a territory for the building of spaceport or even a launching site by another entity who has no territory. That is the emerging actors, that is the commercial, that is the private sectors. Thank you very much.
Thank you. Any questions? Yes, Pam.
Hi, great presentation. I just wanted to go a little bit in detail about your sort of dispute resolution and sort of responsibility, because you mentioned that, a state will remain liable for what happens outside. But in a scenario where you might have one private company that is a national of, let's say, the United States of America, but has obtained permission from, say, a developing country. Let's just name my country, Bhutan, right? It has got that state's permission to go out and do exploration for whatever reason, or sending stuff out. In that scenario, which state would you say is liable then on the basis of what you said? Is it the national, is it the state that the private actor is from, or is it the state from which the actor received permission to go and do what it was doing in space?
I think it should be the state where the private actors from, because it is the state that authorized and licensed their operation in line with the laid down, principles of international space law. Other issue with the other company from another national can also be negotiated, like we have proposed that through diplomatic negotiation, you can resolve most of these disputes.
Thank you. I'm sure everyone is getting tired now, so let's just breathe and take a moment for the very last team, and you guys are gonna blow us out the window, right guys? So thinkers as doers.
Thanks, Timibi. We hope we do.
You will.
I'll start with the presentation, while my colleague Mariah will also assist. During the question Q&A, Akinwale Abraham and John Ode will also respond to the questions. So our work stems on creating a framework, a developmental framework, and creating an existing incorporation synergy where Africa can achieve autonomy, a form of self-governance. And the policy we are trying to address is access and utilization of space resources. Based on Article 1 of the Outer Space and Policy, which draws on every nation achieving the common benefits of utilization of space, technologies, and resources. We recognize the problem in the African construct as a lack of an space industry in Africa. And this borders on the brain drain sustained in the African environment, and some economic policies, and also implementation issues, which has led to a drop in the research continuum among researchers. So what we propose in our model instrument is to allow for a Pan-African construct where space and advanced technologies can create and also improve the economies in the African society. Our legal framework has an underlying strategy, the African Union Objective 2063 of the Africa we want, where we put Africa interests first in achieving all space-oriented policies. And the guiding principles for this developmental framework is to create a room where African nations pool their resources, acting together, so as to climb the space technological ladder while addressing some of other policy gaps, so as to foster commitment among subscribing African states. So the African we want space autonomy in terms of self-governance in a way to achieve interdependence between African countries, where African countries will be core drivers of technology and capacity building in aim to achieve responsible innovation for self-governance. And a high-level view of the African Space Agency Vision 2063, which was proposed at the African Union Conference, took on some old ideologies towards developing social and political economic integration of Africa. Talks of the program for infrastructural development in Africa, climate development in Africa, maritime strategy, African water vision, and also the comprehensive African developmental program in issues of land policy. I would like to hand over to Mariah, my colleague, to give the implementation steps.
All right, thank you very much, Damola. I will be taking over for the rest 4 minutes of the presentation. So as part of our developmental strategies, our model framework, we propose the 6 pillars of the African space autonomy. And these are the governance, legislation, education, finance and investment, technology, and also resources. Now for the government, there should be a presence of a cooperative and coordinated government to provide regulations in space operations, which will foster national development. So the establishment of a regulatory agency, which will monitor and coordinate space activities within and outside space, within and outside African states, and also giving private actors some involvement and more autonomy over space operations. So for example, the design and development of space operations and space applications, and also the space rocket, as it were. And another thing is they should coordinate strategic industrial partnership and collaboration, as well as foster competition among private actors, so that we improve the space industry ecosystem. And another thing is to provide funding and to allocate budget for national space operations. It's not enough that private investors invest in the space industry in Africa. The government should also provide funding for national space operations. So the next one is the legislation. Legislation in terms of providing national regulation and legislation to guide the activities of space actors. We want to ensure that any space operation in African states conforms with the established space policy, for example, the Outer Space Treaty. So they need to enforce policies to promote domestic space operation, and as well as create policies that will encourage direct foreign investment and things like technology transfer and licensing. Licensing in terms of if we want to make use of a certain patent, a certain space patent, on how to develop a space rocket or a space application which is needed, and things like that. So licensing and technology transfer can also feature in legislation as well. And also want to enable investment flooding from private actors, including venture capitalists and angel investors. And another one is to enact policies to promote flexible operations for space operation startups and small and medium enterprises and associated ventures that are into the space industry. The next one is technology, very important. We can't talk about autonomy in space when we don't have the technology for that. So, and this technology should be such that it augments the society building developmental strategies, and it incorporates technological means and competence in space industry. And so things like promoting intensive research and development in space to develop indigenous capacity, and also utilizing this space research and development investment to bring about provision of basic amenities and to raise the standard of living of or decent livelihood opportunities. Another one is to develop technical and industrial capabilities locally or internationally via corporations and partnership. The next one is education. We need to refine and upgrade our existing educational system to support and accommodate national space industry development. So training the required personnel in accordance with the latest space technologies and skills, and also introducing a dynamic educational system to include integrated and interdisciplinary studies, which focuses on understanding and developing space systems, and also to foster synergy between stakeholders in this sense, which means institutions, research centers, agencies, and the likes. Now, the next one is the resources. One of the pillars is the resources. There should be a way for us to explore the local infrastructure and to take stock of the human capabilities and human resources, as well as the natural resources that we have that can help us have the tools or the things we need to start autonomy. And so allocation and rediscovery of available physical resources, and also supporting and enhancing existing indigenous capabilities via training and integration into the industry. Now, the last one is the finance and investment. One of the pillars is finance and investment. There should be access and availability of finance and investment, which is centered on human capabilities, infrastructure, industry, research and development, to increase a share in the global space market. So promoting cost-effective operations and maximizing effectiveness in space operations, and also collaborating with government to make funding loans readily available for viable space operations and research and development. And also to consolidate all the framework to increase the global market share in space industry. And now we also propose a timeline for achieving this space, the African space autonomy. The first phase will be to will be a national synergy with potential space actors. So space actors such as the government, higher education institutions, general public, private actors, and all that must come together to understand a mutual benefit from space industry. The second phase will be to engage in research and development and also personnel training. And the next phase will be to acquire, after the acquisition of those research and development, the knowledge we gain from them, to acquire basic competence in design and development of space system on our own soil by African actors. And the last one is to go out to join the global space actor and to enact all the policies that my fellow contestants have been very much well able to identify, so that we have influence on those policies and able to change them and make changes to them. And so that is our presentation. And I'd like to thank all my teammates for their input and for their incredible work in this project, and also our mentor, Oyefunke Adebola, and also alumnus of the Space Club of Obafemi University, and also the team for the Space Generation Advisory Council. Thank you, and we'll take the questions now.
Excellent. Any questions? Okay.
Sure.
Christopher.
So some of your discussions was bringing together some of this idea of sort of an organization across Africa, and also some of the goals of the African Union. How do you view the interaction of the organization you've described with the AU? Is it sort of within the AU framework? Is it something that would be separate from it? Any thoughts on that?
Let me just take that. Thank you very much for your question. One very good advantage we have in Africa is that the African Union has taken a very good lead in majority of all the activities in space relation in individual countries and then collective states. So that has given a very good lead for the next phase of African development. So in terms of what is happening in climate action, what is happening in food, agriculture, the AU is the fundamental organization that is leading this, which is what is going to help, this self-autonomy we are trying to push for the space industry in Africa. The AU has done enormous work with the African Development Bank towards water, towards climate, towards infrastructure, e-government. And one thing that the AU has been able to identify, which is something we are pushing forward, is that our fundamental problem is still the basic need. When we talk about benefit for all humankind, benefits are relative. Right now, SpaceX just launched a rocket, American astronauts to the ISS, and then looking to the next phase of, moon travel, moon base, and mass human nations. But that is not the benefit we have for an African man. Benefits for Russian, benefit for Chinese, benefit for the European Space Agency, benefit for Canadian Space Agency, they are all relative, you understand? When you come to the African context right now, how space can really still help us is still in the basic part, in terms of food, in terms of energy, electricity, water, fundamentals. That is what we are still trying to push forward here. And we are grateful to the fact that the AU is taking lead on this, which will help, the private PPP, the private partnership, the cross collaborations that we are trying to push forward. And also, because the AU is taking lead, every space agency of individual states always meet, I think, every year or every consecutive year at a program called the African Space Leadership Conference, where they are still able to meet together and deliberate. And one opportunity this gives us is the fact that if these countries can take lead, then they can start talking to their individual countries. They can start, bringing down the rules and regulations, the policies, to help capacity building within their country. Because one thing we are trying to push that will help for the future is that Africa itself has to develop knowledge banking so that we can actually build our space autonomy. So I hope I answered that. We can talk more about that though, hours.
Excellent, thank you so much. So at this point, Matt, so those are all the teams that we have. You guys did a fantastic job. And what's going to happen now? Yes, well done. You're getting virtual claps. And what's going to happen now is the judges are going to go to another room led by Matt to deliberate for 20 minutes and, you know, come up with some comments and some feedback for you guys. The rest of us will stay here and we will hear from our keynote speaker. And so Matt, when will we be coming back together? You're on mute.
We'll plan on being back by the 45.
So that's in 15 minutes?
20 minutes.
20 minutes. Okay, so you guys all go off. I believe you have the link, the Zoom link that Matt's gonna send you, or you already have it. See you back here in 20 minutes. The rest of us, we will stay here to hear from Professor Nkem. All right. Excellent. So we should have all the teams here and whoever else of the participants is left. So yes, so let me give you the floor, Professor Nkem. Please introduce yourself, and we're really looking forward to hearing your insights. Are you on mute?
Yes, I was, thank you. So good morning from me. I live in Michigan, so it's still 11:30 here. I know there are different time zones in your various places, but good to be here, and thank you, Dr. Timmy, for inviting me to make these remarks at this very interesting and inspiring conversation. I followed all the presentations, and I applaud you for all your work and thoughts. So Nkem Kumba is originally from the Cameroons. I live in Michigan. I'm a faculty at the University of Michigan, and I do a lot of work on the science capacity building in Africa, especially. I teach mathematics that's my training by background, but a lot of policy work. Many of us have come to realize that the thing that occupy us, especially as Africans, or as those from the less developed world, what really distinguishes our developmental state from that of the most developed is scientific capacity. Everyone has their politics, everyone has their culture, their preoccupations. They're all humans like you and I. But what the tool that enables some to master the world, unlike others, is scientific know-how. And those things were there in the early 60s. One would probably hear the comments that come out often. That in the 60s, many African countries were giving aid to the Koreans who had just been through war. Ghana was one of them, like Cameroon, where I come from. And what turned the stakes around was scientific development. Currently, a country like Korea, South Korea, has one of the biggest phone companies in the world, Samsung. Samsung alone, as one company, that has a big impact on the Korean economy, employs over 200,000 people in that huge company, of which over 43,000 are computer scientists alone. Just computer scientists alone, 43,000. And then you look at other developing countries and developed parts of the world, I say, when you look at Africa, how many computer scientists do we produce collectively when one company can do that? So we came to see science as the frontier for development. And that observation isn't new. Back in the 70s, the Pakistani Nobel laureate who founded ICTP did notice that. And that's why he founded it in Trieste to train physicists, some of whom went on to help develop the industrial foundations for Pakistan and India. And that's how they became nuclear countries. Now, that facility, the ICTP, Trieste, International Center for Pure and Applied Theoretical Physics, is a strong model for what we call science diplomacy. The thing that I'm following through on this space conversation, in my mind, parallel things that we have seen during the Cold War, where the countries that have the ability to develop the scientific know-how to do things for their national interest and security, they do it with or without anybody's permission. They're the masters of the planet. And so the US could develop its nuclear infrastructure and industry and detonate a weapon as it would like. You didn't have to ask anybody permission. But out of this, you have a race not based on the commons, even though there were cries for the commons. The United Nations was established around 45, just after the war. But despite the United Nations and all the various treaties that govern that proposed common space and a common earth for everybody, the race war still went on. The nuclear war still went on. And it only took some other countries to develop their own capacity to be able to mitigate that race, the nuclear race, in a way that you now start having nuclear treaties that enabled a more tempered atmosphere, that enabled the reduction in the scare of a nuclear war coming up. Now there are many nuclear countries. If there were only 1 or 2 or 3 or 4 nuclear countries, it would be a different activity. Now, how did other countries get to become nuclear as well when they were not developed? And by the way, the technology that some countries that are capable of and developed early in their history, those are usually assets that they don't share very readily. So when you talk about space, space in my mind is basically the scientific enterprise, the ability, the capacity to even engage space as a frontier is based on scientific know-how, and those who know it dominate that space. And those who are not spacefarers, as we call it, which simply means not the capacity nor the know-how to engage at a certain level yet, they are users of what others do, or they are simply trying to find space so that they're not completely left behind. A key tool that has enabled other countries, if you look at if we take the parallel of the nuclear race, was science diplomacy. So science diplomacy has about 3 components. And a good, an effective example that I will share again is one with a country like Israel, Pakistan, and India, who were not nuclear at the beginning, but recently become nuclear. They don't belong to the traditional club of the dominant powers of the world, but then they can hold their own ground and negotiate their own space, both for their own countries or their own regions, or you want to call it for the rest of us from on the globe. Science diplomacy has, those 2 words took more and more meaning because the things that negotiate global existence were more scientific in nature. There was a pre-industrial age, the industrial age, and now the knowledge age. Those terms, industrial to knowledge, are undergirded by scientific know-how. It's a scientific enterprise, the advancement, the technologies that come out of physics and chemistry and mathematics that enabled those quote-unquote science, different connotations of society. Now you hear about the 4th industrial revolution. Well, to the policy people or to the legal mind, it comes out as the industrial revolution. But to those who actually champion and advance it, they understand it's science that's behind that. So because science became a big enabler and undergirder of our existence, then things like diplomacy, where nations negotiate their interests and prosperity, where they see themselves as nation states, go from just isolated personal and national interest to maybe the commons. And so diplomacy and science got to merge. There are 3 components to that. Diplomacy, science in diplomacy, first of all, is one where science informs advice to people who do diplomacy and international relations. So foreign ministry, prime ministers, heads of states, those who ultimately formulate and manage policies for their regions, for their countries. The scientific advice that they receive, countries that go negotiate international activities, be it trade, be it military affairs, be it peace, without understanding that some of these things are undergirded by scientific know-how, they usually fall short. So science in policy, in diplomacy, is one where science advises policy. In places like the US, the White House has an Office of Science Advisors, a whole committee that does that, that brings the best science. State Department has that, USAID has that. Many of the main institutions in the US have that. But if you go to other countries that are not that well structured yet, there is a discrepancy. So there's less of that in the policy making, diplomacy making policy establishment. And so when they go to negotiate at the international level, be it climate change, be it environmental issues, be it even agriculture, the science undergirding the language of negotiations has to be understood, otherwise one has a disadvantage. The other aspect is science for diplomacy. So this is where science can enable diplomacy. There are instances where nations are at odds with each other. You know, the Cold War was a good example, where despite the US and Russia barely having anything to do with each other, at least publicly, the scientists were talking to each other. There were scientific committees, to the point where a committee of US and Russian scientists that had worked for a long time, they ended up being the ones that advised their governments on nuclear arms treaty. So there was scientific activity between nations, even when they are at odds. US-China is one of them. So the Cold War was only cold in politics. Scientifically, it wasn't cold. That's science for diplomacy. It thaws the atmosphere. It gives a back channel for communication, where science is more transparent, more straight, and you have less contentions, a common vision. The same formula for mathematics or physics will be the same for everybody. It's not opinion. So science can be a good tool for diplomacy, where there are difficulties in direct political and other emotional attachments. The third aspect is diplomacy for science, and I think that's where we might find more resonance here. The kind of things together we're discussing here on space as what the US will call the next frontier. You know, I'm sure you're probably familiar about our President Trump in his last State of the Union address, announcing the establishment of the Space Force. Space, for people who know what they are doing, it's a military space. It's a military zone. It's space for dominance, geopolitics, who is who in the universe. So when you hear things like that, you know, those who are not spacefarers yet, like the Africa and Asia, Latin America, South America, the relevance in this conversation becomes more stronger when you have some scientific competency on the table to validate that. Even at the level of making legal communications, the legal framework is not abstract, just on space conversations. There's an undergirding scientific content, the language. I mean, I would make this, even here within the US, the law enforcement, the police, they need to know some science, forensic science, you know. Investigations now are scientific. You have to know have the tools. So when one looks at diplomacy for science, it's a frame where nations that need to know science or want to acquire science or want to put science as a good for themselves, maybe space science, agricultural science, maybe trade science, they use diplomacy for that purpose. Yeah, an institution like UNESCO is one where put science, the S there is for science, to help kind of democratize science, if you will say it that way, globally, and empower the SDGs. Science is a big component of it, to try to enable those who are less scientifically competent to have some science. So many nations use diplomacy for science. bilateral relations, bilateral cooperations. A place like Africa, there's lots of bilateral aid that comes to the continent, be it European Union support, be it Chinese nowadays, be it whoever is a partner in development. What kind of development are we talking about? Do we end up as Africans receiving technology that's produced abroad and given to Africa as an end product to use? Or do we, in those diplomatic relationships and engagements as bilateral partners, also negotiate not only the technology, but the science for know-how? So you have diplomacy for science. It is one of the key tools that a country like Israel has used to be scientifically a powerful country now on the globe. It's a recently created country, 1948. It's just about the same time as African countries. How come they are this powerful globally? A big tool for them has been scientific diplomacy, has been diplomacy for science. Using their diplomacy. Okay, Timmy, are you talking? I cannot hear you. You're muted.
Yes. Can we round up so we have some time for questions?
Okay. So diplomacy for science is a big tool that in these conversations, it might be worth putting on the table so that in discussing the legal framework or all the other aspects of space, one recognizes that the underlying knowledge of the science in all its breadth and variety that enables scientific space exploration, that enables the tools, the satellites that are there, the economy of space, the science that enables that. Can this conversation include that aspect to enable those who are non-science, who are non-spacefarers yet, to know really what they are talking about when they say space at all? Otherwise, there's a void that that ends up almost at an accelerating rate, increase the difference or the distance between the developed or the non-spacefaring countries and the spacefaring countries. You said in many other domains where the distance between development and underdevelopment is increasing. That distance, that increase is predicated on scientific know-how. And diplomacy for science can be a good tool that it can be incorporated to enable some kind of minimization of that distance increasing. So maybe the time is, I'll leave it at that point.
Thank you. Does anyone have any questions?
I really do.
Yes.
From my understanding of what you said, sir, it's borders on technology policy for nations and African nations now. Is there a book you could recommend to understand the depth of what you've shared, sir?
I would share that with the organizer, my colleague, Dr. Timmy, and she would in turn share that with the rest of the group as necessary. It's a whole area. There's technology policy. There's policy is one, but know-how is another. Policy for know-how is a whole different topic, as opposed to policy for acquiring end products. I give you a very mundane example. When African governments nowadays, as we see them, negotiate with the Chinese counterparts, the Chinese come and construct the infrastructure. They don't come and train the Africa side to construct their own. The policy brings the end product. It doesn't enable the know-how that can give you the independence that you're suggesting to be valuable in that picture. Same thing at the space level. So that will be diplomacy for science. Correct.
Thank you, sir.
Great question. Anyone else? Let me put you on the spot, Group Alpha. Do you have a question?
Sorry, I was just muted there. As a lawyer, then, I would want to know that what are the kinds of, I suppose, space laws and policies that would bring about development? I'd say in the context maybe of the use of Earth observation satellites or satellites for sustainable development, or really any kind of space endeavors that speak to sustainable development. Is there really a policy role that can be fulfilled in that regard to bring about this initiative?
Yes, again, that the relevance here will be diplomacy for science. It starts with my earlier observation that ultimately, there are many arguments about development, macroeconomics, climate change, all the things that dominate global discussions, the planners of what happens on this earth. Those are there. But the distinction between development and underdevelopment is scientific know-how. Science creates the tools that make a difference. If that is put on the table, then all the other discussions about policy, about bilateral activities, about the legal framework, about everything else, put science as an enabler, or one that, if well harnessed, can help minimize the disparities that even bring about this conversation in the first place. So diplomacy for science, and again, I will make some references, both articles and books may be available to my colleague and host to share with the team. And we can even pick up this as a topic, if you want, if you will. It's not only isolated to space, again, it's in every aspect of global development. The disparity between the rich and the poor, the developed and the less developed. You see very clearly, everybody is human flesh and blood, but who knows the science to do the things, and who doesn't know it to not do anything.
Excellent. Any other questions? So let me give a question out, because one of the things that was part of the things you had to think about in this contest was responsible innovation. What does it mean to be a responsible actor? Because when you're coming into the domain, that's the first thing everyone's going to look at. How are you a responsible actor? So how do we ensure and think about that as everyone comes in, Professor Nkem, about being responsible actors in space?
So that question again, for me, given my background in these issues, it's hardly well situated. I am not sure that in a world where national interests, especially the most powerful countries, drive the global agenda, the issue of responsibility can be easily put on the table as a commons. That's a moral question. And I'm not sure if national interests for any country are driven by morality as opposed to their own power and security and prosperity interest. So there might be a need to talk about responsible innovation, but even if we were to discuss that and put on paper as a framework, only those who know what it means can implement or work on it. So responsible, if I may temper a little bit and just handle on the word responsible. One of them would be to say establish or think of a framework under the policy apparatus where, like the ICTP I mentioned earlier, the National Center for Theoretical and Theoretical Physics. It was a center where people from the developing world, mostly Asians, and because it was founded by an Asian, but African, that has trained more African physicists than any African university on the continent. It can be established as a collaboration among universities, that's an innovation, to train space scientists in the physics and the chemistry and the mathematics that's required, or whatever, you know. And in terms of innovation, one of them can be when non-space faring countries interact in this conversation. One of them can be to put aside, because there's lots of money in this space, big time money that moves around, quote unquote capacity building, where you have bilateral structures and funds to focus on training a workforce that can discuss space competently. And so I'll give you the Israel example. Between Israel and the US, there is a bilateral science fund that is $1 billion a year. And that's how Israelis are trained in the most advanced science. You've gotten over 40 Nobel laureates out of that. And so that's innovation. The traditional policy structures do not enable this kind of transfer of knowledge and to those who are less fortunate, at least less endowed with this. So for me, innovation is structured that way will go around the kind of arrangements that would enable the training, the development of a competent workforce that understands the details and can make more competent recommendations in this space.
Great place to stop. Thank you so much for those words. Matt, you are back. So can you lead the discussion? Is there a representative that's going to tell us what the outcomes were?
Yeah, I can go over them from the group. So there was a lot of discussion between everyone trying to figure out where to place. Everyone was incredibly competitive with the ranking. We ended up having to start splitting hairs. We ended up finally coming out with 3 teams to come out on top. Just to clarify before I go over this, Timmy, do you want the ranking or do you want just the top 3 teams?
Let's have the top 3 teams.
Okay, so after we talked about, or after we went over it back and forth, where I reviewed the scores, reviewed the content of conversation, judges ended up settling on the top 3 teams as being Team Alpha, Team Thinkers as Doers, and Team Perseus to take on the best teams for the 2019 Space Governance Innovation Contest.
And does anyone want to make some comments about what your general thoughts were? Maybe I can start off with asking Christopher Bourgeon.
Sure. I mean, just a couple of quick comments, really by way of congratulating all the teams involved, and for the 3 teams that were just mentioned here. The oral presentations of all teams was really excellent. This was a lot of complex material, and we were really impressed by sort of the work of each of the teams in terms of working as groups, bringing together ideas of both law and policy, and bringing the different perspectives that you had to this. The 3 teams that we mentioned in particular, we thought had particularly superb presentations, and both strong in terms of bringing out a variety of ideas in both policy and law, as well as showing aspects of teamwork and oral advocacy. So really congratulations to everybody involved. This is really this is a really a great achievement, and we're all, I think, looking forward to not only this year, but as this moves forward in the coming years, what will be happening, and seeing how this grows and evolves. But congratulations and thank you to all the teams.
Excellent. Thank you guys so much. I would love to bring Dami Lola and see if you have any words for the students and participants.
Yes, thank you very much, Team AB. I just want to say how impressed I've been listening to the presentations from each of the groups. As some of you may know, my background is in environmental law, so it was quite interesting to see the intersections and some of the arguments developed by the students to use environmental law principles to buttress or reinforce space law. And I think as they were talking, I started to jot down the title of my next book on what space law can learn from environmental law. So I think it's the students did very great. I think for competitions like this, it's clarity of thought, organization, and the ability to answer questions intelligibly that judges normally look for. And I would say that it was a tough choice for us because the groups did very, very well. And I wish them the best as they move forward. And I look forward to staying in touch. Thank you.
Thank you so much. And our partners in this project were Space in Africa, the Lagos Court of Arbitration, and the Outer Space Institute. And the reason we partnered with the Outer Space Institute is because they really have this thing well crafted about the importance of bringing science and policy together, right? It's no one should act in silos anymore if we really want this kind of this future that we're all envisioning. So I would love to give the last words to Aaron, who's our partner from the Outer Space Institute and who's a scientist. I hope you noticed we started with a scientist, we had a scientist in the middle, and now we're closing with a scientist to really help us lawyers really think about, this is the foundation of space. You can't do space without understanding the science, understanding the technology. So Aaron, I would love you to give the final remarks.
Well, thank you. And on behalf of everyone listening, I want to extend my thanks to Timiebi and the rest of the organizers, to ANCOM's keynote, the Interplanetary Initiative Space Advisory Project, Space Africa, Lagos Court of Arbitration, the panel of judges for their hard work in organizing this event. And a very special thanks and congratulations to all the contestants for their hard work and insightful work. So I'm a planetary astronomer and professor at the University of British Columbia. I am also the director of the Outer Space Institute, the co-director. which is a transdisciplinary network of space experts interested in sustainable development of space. The network includes social scientists, astronomers, planetary scientists, industry representatives, and policy and law experts. So the reason for this network, and we are by no means alone in what we're trying to accomplish, is that we need many different viewpoints and backgrounds to be part of the conversation on how we're going to continue to use and expand the use of space in the decades to come. This is why the work that all of the participants here are doing is so important. So as a scientist, I can say I never really thought I would become involved with space policy. But the more I learned about the issues, the more I realized that we scientists need to be part of the conversation and to educate ourselves on the issues of space governance. So look no further than the sudden outcry by astronomers as SpaceX started to place in earnest Starlink satellites. So this should not have caught so many astronomers by surprise. And if we had been looking at the issue more closely, we may have been able to better find a sustainable path forward. Now, astronomers, in my opinion, should not prevent the connectivity that will be brought throughout the world as a result of mega constellations. But companies and space agencies should not be able to fundamentally change our sky, whether for the professional astronomer or for those who simply want to enjoy the night sky. So I think it is important to note that the rise of mega constellations is not the first time that astronomers have been shocked by the use of space and became deeply involved with policy. So the placement of the Iridium constellation was one instance, but the first was Project Westford in the early 1960s. The United States placed almost 500 million copper needles into orbit, with implications for radio astronomy. Now, some of those needles are still in orbit, and they're adding to the debris problem. As the teams here identified, what we do today has implications for decades and potentially centuries from now. Mega constellations will be able to avoid self-collisions with strict station keeping, but things go wrong in space. Maybe this means an accident or maybe a purposeful action by another actor, such as a poorly executed counter space demonstration, an issue that some teams brought up to the concern of militarization of space. So regardless of the reason, going wrong in the new space era has major consequences. So treating space as an environment and not outside of the environment, as well as making stronger connections with liability, all these concepts are ideas that participants brought up, might help us find solutions for preventing the loss of the use of multiple orbital regions. As teams here discussed, orbital slots need to be viewed as a limited resource. Collisions do happen and space traffic management is desperately needed. So just think of SpaceX ESA communication breakdown, which resulted in confusion on who should maneuver to mitigate a collision risk. These are not easy problems given the past practices. Yet resolving these issues will be critical as we move forward beyond Earth and establish a continuous use of the moon, lunar orbits, cislunar space, asteroids, Mars. We cannot extend the orbital debris problem to other regimes. If anything, the moon does not have an atmosphere that will protect actors working on the surface, which can raise the stakes for how lunar orbits and cislunar space is used. Activities on one section of the moon can affect other areas, for example, dust fountains. So I first heard about space mining as a graduate student, and I dismissed the idea as being utterly ridiculous. In part, this was because at the time, the focus as presented was on gold and platinum. But I was recently forced to revisit the idea, and I have to admit I saw it in an entirely different light. And that was because it was put in the concept of water. Water is rocket fuel. Water is radiation shielding. Water is life support. And I should have realized that sooner. And if I had, I would have realized that 14 national space agencies have identified in situ resource utilization, space mining, as a necessary capability of moving forward. Platinum and gold are still mentioned, but there are 4 printing spacecraft components in space. So space resources will be critical for future space exploration, particularly for long-term crewed exploration. And this is when I realized that space miners are indeed serious, which fostered a science concern in the back of my mind. On one hand, space resource extraction will allow sampling celestial bodies at a level never before seen. We have very limited ground truth in planetary science. So that is knowing the material, what material you have and where it came from. Things such as meteorites allow us to sample celestial bodies, but we don't have the ground truth. So this is why Hayabusa 1, 2, OSIRIS-REx, Apollo, and Mars missions have so much importance. And the science possibilities if multiple actors are working on celestial bodies are amazing. We can learn so much about our origins. Materials from asteroids contain the oldest materials that you can ever hold, dating to the very formation of the solar system. Ices on the moon are an accumulation of material from the outer solar system over eons. But with multiple actors, including many private actors in the game, how will proprietary practices affect science? One concern of mine is that the practices needed to extract space resources will be incompatible with the extraction of samples. The same measurements needed to judge how well mining is coming along will be different from those that are needed to understand the relative formation ages of minerals. So I'm almost done here. Scientists and policymakers need to make sure that they are talking with each other. If we are to say you cannot appropriate a resource if it is in its place on a celestial body, but that maybe you could appropriate the resource if it is taken from its place, how can we ensure fair use, as teams brought up, for the benefit of humankind and ensure that this material, which could hold key information about our past, is managed well? As teams brought up, coordination, synergy, transdisciplinarity will be incredibly important moving forward. Knowing what different groups view as a benefit, as teams articulated so well, is fundamental to the conversation. And finally, scientists need to be involved with policy, and the policymakers need to absorb as much science as they can. As Encom said, science diplomacy is a key tool for working together and advancing societies. Space is big, but so is human ambition. To manage it well, we require groups such as the teams here to be part of this conversation on space use, and it is incumbent upon all of us to listen with open minds to those who speak up. So once again, I thank all the teams for an incredible job. Very well done.
Thank you so much. Thank you. And I guess the very last word with only 1 minute should come from a student, a participant. I'm gonna choose an engineer. So go ahead, Oyedamola, take us out.
I really want to thank the team for creating this avenue for us to express our ideas. I was an engineer, now I'm a scientist. So it's great to understand how policies could interplay to create essentially wealth for the less developed countries through action and interpartisan efforts. So I really thank the initiative of this project, and I also appreciate our team efforts, which allowed us to think differently as engineers, as scientists, as policies, while creating innovation as the forefront for African development. Thank you.
Great. Okay, so Ben, any words, last words, Ben, from ASIL?
Just another thank you to all of you for joining us today, and congratulations again to all of the teams involved. ASIL is thrilled to have been a part of being able to host this event and being able to put this out there for everyone to see. So thanks again, everyone.
Thank you. All right, guys, thank you so much. Bye-bye.